Today, I've been asked to speak about representations and warranties, particularly in the context of the purchase and sale of a business. There are all sorts of contractual terms, as you can imagine, in any sort of purchase and sale agreement. Obviously, in an asset purchase agreement or a purchase and sale agreement, every one of those sections has a purpose. But the reps and warranties, the representations and warranties, in particular for the seller, is a critical component of any kind of asset sale. So just to take a step back, I think we, like a lot of legal terms, we kind of take for granted that we throw around reps and warranties ad nauseum as we talk about certain deals and what we're working on. But representations and warranties, just from a definitional standpoint, we should understand kind of how they work together. Representations are those facts about the business, the material facts that we'll get into some specifics that are being presented to the buyer for their consideration. And they may ask for all sorts of elements of the business information from you, understandably so. So those facts are the representations. The warranties then work in concert. That is for lack of a better word, the guarantee that these facts as they're being set forth are accurate. And there's an indemnity that goes with that then that says essentially, right, that if there is anything here that is not an accurate representation, then the seller will somehow have to indemnify or make right whatever inaccuracy there may be. So the representations are the factual part of this, and then the warranty is kind of the guarantee or the indemnity portion of the section and what it accomplishes in the context of the agreement. You can imagine then when you're setting forth all these facts that have to do with the business that's being sold and kind of the warranty of those material facts having to do with the business, that would make a big portion of the agreement. And I just looked back earlier today and just looking at the last couple of deals that we've done to see, what portion of these agreements are dedicated to the representations and warranties. And sure enough, in one of the agreements, I'd say just about half of the pages of the entire agreement were spent on reps and warranties. And the other one, maybe 60 to 65% of the agreement was dedicated to reps and warranties. So you can see then that not only, and I guess I would say one caveat just to take a step back, that actually does not even account for all the supporting documents that we'll get to in a little bit here that are also part of the transaction that make up for even more volume of material to be produced and reviewed. So again, it's an important part. Every part is important, but the reps and warranties, particularly in the purchase and sale of a business, are important. And very much so for the seller. The seller then has a disproportionate share of reps and warranties to make as they set forth all these details about their business. The purchaser, the buyer, has some reps and warranties as well, but they're much more general in nature ordinarily. So let me start there. I think just to talk through some of the general reps and warranties that we see. They kind of function like any general provisions may function. So there's the organization, representing and warranting that the company is in good standing. There's the power and authority provision, representing that the company has the ability to enter into this agreement and perform as they're contracting to perform. Consents, conflicts, is another general term. And there are a couple of different elements that you see sometimes with the conflict section, but that this particular agreement is not going to be in conflict with other agreements, potentially causing default or acceleration on the other contracts, but also that there's no conflict of law, that everything that's being put forth here is amenable with applicable laws. Enforceability is another general term that basically saying that this agreement is duly executed, valid, and binding on the parties. And then, of course, usually near the tail end, there's something about full disclosure, a provision that essentially says what the header says, and that is that everyone has fully disclosed the information that's been requested and all the supporting documents have been provided. So those are kind of the general terms. And I would say that those terms, consent, conflict, organization, power and authority, that those things then you will see as general reps and warranties for both the buyer and the seller. Where we get into the more in-depth reps and warranties, then just think about the scope of different sections of your business. I guess sections is probably not the right way to say it, but think about the different elements of your business, right? So there is the financial side, and so you will see all sorts of reps and warranties for financial statements, accounting, revenues, benefits plans, tax matters. So there are those pieces that require representations in full. They're the assets themselves. If you sell substantially all the assets of your company, do you have marketable title to all the assets that you're selling? What about the sufficiency and location of those assets or the condition of those assets? So making those representations. Of course, you've got employees. So setting forth, anything that relates to labor and employment. Do you know or have you been dealing with any complaints, any threatened labor strikes? Can you provide a list of your employees, and their agreements should be produced? Have you run any background checks? And then, of course, you've got kind of related there, subcontractors, if you have any subcontractors, or if you have any particular types of contracts that may impact, the employment of folks in the service of your business. So maybe government contracts that come with certain requirements as it relates to employment. So again, these kinds of sections are meant to be examine the different elements of your business. And I guess just to take a step back before I get into some of the other sections, in concert with the reps and warranties then are the disclosure schedules, which are produced in support of the reps and warranties. So it is not simply a representation of here's a list of, or here are my employees. It is providing a list of those employees. It is providing their employment agreements, producing all those supporting documents, and scheduling them. And there's a lot of back and forth then, you can imagine, that as you produce some of these documents, other questions may arise. What about this person? And who's part-time, who's full-time? And do you have subcontractors? And what is the list of subcontractors? And do we have copies of those agreements? You can imagine kind of the layers of supporting documents that you have to produce, and the back and forth that occurs as you kind of try and sort through the follow-up questions that naturally will arise as the closing date gets closer and as more information is required by the purchaser. So a couple other things that are more specific. There's a litigation rep and warranty often. Is there any Have you had any litigation, been involved in any litigation over the past 5 years or so? Or is there any pending litigation? Obviously, a purchaser will want to know if there is any litigation on the horizon, or any, potential claims out there that may be outstanding. They will want to take that into account then as they look to purchase your company's assets. Same thing then, there's another general, where I guess it's a specific rep and warranty, but it shows up in every agreement that you have, and that is environmental matters. As far as your business, your facility, if you are the seller, can you represent that there are no environmental hazards, or there have been no leaks, or and there's quite a bit of detail to the environmental matters section. Again, if you think about this in the context of the transaction, it is, there are a couple of different parts of what we're trying to accomplish with the reps and warranties. It provides a detailed view of the business. It provides a roadmap, I think, for the due diligence that the purchaser needs to do, or the examination of the business that needs to be conducted and that the seller helps to facilitate. And importantly, thirdly, the reps and warranties will survive closing. So it is meant to be, a detailed view that not only gets you to closing, but that survives closing as well. Let's see, a couple of the other reps and warranties that we see from time to time, or pretty consistently: insurance, trademarks. People want to know if there are any trademarks that are being purchased, and information on those. They want to know the trends when it comes to the business. Has there been any adverse change? This is something that we've seen quite a bit with COVID, that for deals now, everyone has kind of dealt with, or not everyone, but quite a few businesses have dealt with some difficulties as a result of the pandemic. And so beyond that, though, I think people understand that the businesses generally have been coping with some challenges on that front. But there is also, the question: have there been other adverse circumstances that the business has encountered? You should disclose those. So ultimately, though, these reps and warranties all serve the same purpose, which is, again, to give the detailed view of the business, to provide, the mechanism for due diligence by the purchaser, and facilitate that sharing of information between the buyer and the seller, and to provide that kind of warranty of the representations for the purchaser. I think ultimately, a couple of the takeaways that we see as a result of going through or helping to facilitate these types of asset purchase transactions is that, particularly on the seller side, since they bear the majority of the burden on the reps and warranties, is that the more we can help proactively, like before maybe even the seller is contemplating selling the business, the more that we can help to be current on a lot of the business paperwork, or be current with the finances, be current and keep good records on our employees, or what have you. The more organized you can be as a habit or as a routine in the operation of your business, the easier this process is, because it can be it can feel tedious, and it can feel cumbersome trying to pull up every contract that you've had relating to this part of your business or that part of your business, or trying to produce all the documents that are being asked of you. It can be it can be a pretty overwhelming experience, especially as more and more detail is sought, as you also feel the pressure of closing the deal looming. And so the more that we can help as attorneys in the operation of the business, the better that we can kind of approach a situation with an asset purchase deal on the horizon with confidence. And that's kind of what we strive for with our clients. You know, we want to have that relationship with our clients so that when it comes time to celebrate, you know, the sale of your business and work through that process together, that it is part of, you know, the general life cycle of your business that we've been partnered with you on from the start. And so that's our goal, is to help, you know, at every step along the way. Of course, we've got folks that reach out to us and say, you know, I want to sell my business, or I've got a potential buyer, can you help me? Of course. And we are there to provide that service to the degree that we can have an ongoing relationship and it culminates with the sale of the business, even better, even better. I will say one other note about reps and warranties that I think I would touch on is when there is risk associated with it. We've seen more and more now that some deals, the purchasers will require reps and warranties insurance. And I don't have the data to back this up, but it certainly seems like that is more frequent, where you can actually purchase a policy to protect against any potential breach on the reps and warranties. We also often will see a holdback amount, where some money is left in escrow for some period of time, maybe for a year plus, where if anything comes up that is a breach of the reps and warranties, that the purchaser then can seek some compensation, some measure of damages from the holdback account over the next 12 months or so, before that money then gets released ultimately back to the seller. So holdback or rep and warranty insurance, a couple of the things that are in place, I think, that we use as tools to protect against or protect for any potential damage that results from, you know, some inaccuracy or something that wasn't contemplated in the reps and warranties. So that's really it. You know, I think as we kind of look at the type of work that we do, or as we advise clients in the sale of their business, largely, you know, this is where we spend the bulk of our time, whether it's looking at the asset purchase agreement itself, or actually working through each of the representations and providing the accompanying documents and disclosure schedules in support of those representations. That's where we spend a lot of time, and where our clients spend a lot of time. And so it's worth kind of having a general understanding of how the reps and warranties function. And again, and if there's a way to kind of prepare yourself for that, if a sale of your business is on the horizon, or even if it's not, to think about how you operate your business on a regular basis, so that when that day or that eventuality arises, that it's time to sell, that it makes for a much easier, seamless process in kind of producing what you need to produce and facilitating the sale of your business. So that's about it. Thank you for joining us. If you have any questions, you can reach out to our business and real estate team here. Personally, my email is eliy@beresfordlaw.com. And you can find us on the web at Beresford Booth PLLC. Thank you very much. Have a great day.